Good afternoon, everybody. I am JD Houvener, and welcome to the Bold Inventor Show. I'm with Matt Kulseth, my co-host.
Well, hello.
Hello, and brr. I was preparing my voice, which is the very first day of kind of a cold coming on. I don't know if I'm sure you've had that, where it's like, yeah, something's not right.
Yep.
So I thought I would pull up an article and kind of learn how to enunciate.
We're doing some voice stretching prior to the show.
Wow.
Really getting the pipes in tune.
Yeah. Right. But I'm feeling hoarse though, so I'm trying to make up for it. So here we are on Wednesday. We do a live broadcast. Right now we have 0 folks that are live, and we want to get the word out.
Thanks for joining us.
We can only go up from here.
Yeah, right.
And just know that if you do want to find us live, you happen to be free in the afternoon on a Wednesday at 1:30 on the West Coast, 4:30 on the East Coast. We're here. We're here for you and all of your intellectual property questions. We're Bold Patents, but we'll handle Bold Trademarks as well. And we'll take on really pretty much any intellectual property question, and give it our very best shot. So today we have no guests, unfortunately. So that may be why we're, you and I are maybe it's old hat. People don't want to check us out. That's why we got no live viewers. But
what do we not have any new clients?
Oh, we do.
I'm just kidding.
We're just busy doing legal work. They're doing that, but we're here just talking on air. No, we have plenty of that. In fact, I was showcasing earlier today. I was speaking with an owner of an incubator, and I do some networking, online, virtual, Zoom kind of meetings with different folks. But this was a great meeting where he's international. He helps startups, entrepreneurs, and just inventors with getting what they need to get on the road. And what I loved about this guy, I'll shout him. His name's Carlo. And what in the heck is his company's name? I'm going to give him a full shout. I'm going to be sending people to him. With innovationdiscovery.com.
Okay.
And so it's okay. Bottom line, a lot of these folks are great. And what I normally hear is that, yeah, okay, great. First meeting's $500. Next one's going to be, $5,000 a month. No, this guy work on straight revenue share. He'll do a revenue share, equity percentage for some. Cool. And he said it's a success rate. He only gets paid if there's success. So, I mean, hey, for someone who's, does not have a business background, and for a lot of our clients, they're just tinkers, they're scientists, they're just, technological, let's say, right? Just really more focused on the solution, and have never brought anything to market, don't know anything about raising money. The innovation discovery, I was really impressed with this guy, Carl. So he's international. They do a lot of business overseas, but they have a lot of U.S. clients as well. So I'm gonna be sending out people to Carlo. And anyway, I was sharing with him on our website. Quick little plug to boldip.com.
Great website, all the content you'd ever want.
Tons of information. One of the coolest things, I update once a month, and I did it today. Don't look at the facial warm-ups, but this is our homepage here right now, right? We get patents for you, whether you're a gamer, a parent, a realtor, fisherman. Do you see we've got fishermen in there?
Truckers, you get a patent. You get a patent.
Right? Contractors, you. Okay? And so I want to showcase that real quick. But then here, we do have almost 300 now. So we're being humble when we say 250 plus patents issued. Click on that link right there. Look at this. We get this whole list of patents that we've helped our clients get to date. And the most recent one here, DeAndre Ryan, for a portable retractable reeling for a medical device. And so anyway, you can take a look at that, pull it up, look at the different categories: gaming, food, physical science, construction, all of that. So
and by the way, for the folks listening at home, this is all public information. It's all publicly available. There's no waiver of privilege, anything like that.
100%. We only publish those when they get issued, right? And so there's zero risk to attorney-client privilege or confidential information getting out. So that was a funky little intro. I do want to make sure I mention that we are attorneys, but this is not going to be a place to get or receive legal advice, but you can bring questions about intellectual property, about where you're at, maybe pose hypotheticals if you want to. Ask questions. We're here. We got one live viewer. Give us a like, subscribe to our YouTube channel. I push out new videos every week on Tuesdays, so it's great information. I want to, increase the knowledge of the inventors out there, even those that wouldn't even consider themselves inventors. People like you and I, Matt, that are out there just, hey, tinkering. Hey, you're an inventor. You are definitely.
Yeah, I'm a recovering inventor.
I filed something one point, but no, I enjoy the business of law and helping us reach more inventors and more clients to be able to serve as many as possible. That's what we're doing here on this show. So without a guest, we have some preloaded questions that came in. And one of the coolest places is no longer Avo. Avo, people aren't going to Avo and asking questions anymore.
Are we going to the front page of the internet? Are we going to Reddit?
Pretty much. Hey, we got Philip on. Philip Swing, good to see you, buddy. Just spent the day wrestling with a written opinion from the PCT. Oh, international, sir. Okay, well, good. Don't ask me about that. Just kidding. That sounds like there's probably some sort of office action. Looks like. Cool. Well, let's see what we can do with our Reddit. We've been stirring up some pot, and one of our admins has been reaching out and finding questions.
Oh yeah, I'm just between you and me, JD, I'm a big Reddit guy.
Okay, here it is. He's not.
I do like the Reddit. I like the snarky responses on Reddit.
Oh yeah, you get right to the core of the answers, like the techie, nerdy, slap you in the face answers that you really want. You're not going to get fluff. You're not going to get sponsored ads. You can't get the slime. So it peels back layers of slime. So here's a question, and this one, we do owe you a response to. So I thought I'd double dip here on this question. I'll bring it into the chat. This is the old symbol question. So if you trademark your business name, which you don't necessarily have to do, can you use the R symbol on your logo once it's approved? Noting the long is a stylized version of the trademark words. In theory, couldn't somehow, but the symbol R every time they mention their brand name in plain text.
Okay,
we'll understand that, but go ahead with your answer if you
got it. It's a little convoluted, but we'll untangle it, as it were. Ooh, so yeah, JD's right. You don't have to trademark your business name.
Wait, I'm going to rewind that. Let's rewind it 10 seconds.
There's a difference between a business entity and a trademark, right? So your business entity is your LLC, your corporation, your 501c3. Those are business entities.
Yeah.
They can or cannot also function as trademarks. So for example, Kulseth Law is a business entity, a PLLC. My business is Mighty Marks, work for Bold IP, right? Those are the trademarks of the law firms. So that is the trademark. The question I think is that, if they file and register a design mark, is it kind of what it sounds like? Can they also use the registered trademark symbol for the words themselves? So let's imagine, we have Bold IP has a logo. We filed and registered that trademark. Let's say JD doesn't have a word mark registered for Bold IP, which of course he does because he's smart. Can he use that design mark and say, I have registered trademark rights in the word mark or the letters of Bold IP? And the answer is no, right?
There it is.
You need to register both to use the trademark registration symbol on both.
Got it. And if you haven't yet registered, it is the TM, correct?
Yep, it's the TM, for unregistered common law right trademark applications. So until it registers and you have the registration certificate and a registration number on file with the USPTO, your trademark is live in good standing, then you can use the registered trademark symbol.
Got it. I loved your answer, mostly because two parts of that were JD's right and JD was smart. I mean, you really worked those in.
Thanks. I got a lot of experience around here, with my wife, making sure, she gets the praise she needs. So
absolutely. I'll take it. Okay, let's go over to patent question. We're gonna kind of flip flop, and again, we'll keep those live questions coming. And by the way, Philip says, the same way in Canada, with respect to the R and the TM. So here, this one could be another foreign question. So hi everyone, I submitted several patents last year. Gosh, all right, avid inventor, and they are all still in the OPAP art unit without having been given an examiner. The estimated first action is 5 months, yet it's been 20 months without even being to an art unit. Is this normal, or should I be concerned? Well, unfortunately, it's sort of a new normal. The wait period is atrocious. And what's worse is that if you file a normal application, meaning an unexpedited, 1.5 to 2 years before first action is a reality now. They just switched away. So no longer can you go to what's called private pair, which was access for only the practitioners to get access to see. And actually, we used to get a PDF that would be submitted by the administrators to say sort of an estimated first action. Hey, you're about 16 months away, you're 5 months away, you're 4 months away. That's gone with the new patent center. So we no longer have any sneak peek or estimate as to when you'll get a response. So
that's crazy. 20 months, huh? For the trademark side, until your first office action or your first initial review by an examining attorney, it's about 10 months, which is
okay. Yeah, that seems long. Yeah, it seems quite long.
It is. When I first got started, it was about 3 months. So
yeah, goodness. Well, I mean, so just silver linings, right? Is that you've got your patent filed, your patent pending, meaning that you've won the race. No other inventor in the world can now file the same application. You have won the race. Okay, you've got that locked in. And so long as you just get ready, and on one thing you can do, which I always encourage while applications are pending, is to bring it into the world, right? Bring it to market. So produce it, design it, get it refined, and start selling it. Huge advantage there. What you're going to get is maybe some ideas for the next version. So with next versions and iterating, you can try to add in more detail. Should you get an office action, you can try to change the words to line up better with your next version, or simply file what's called a continuation application that uses the core spec of the original filing, but adds a new matter, right? Continuation in part, it's called. And you can get additional, basically build your portfolio out while you're pending. So that's one positive thing. And of course, label all your products, anything that's patent pending, put patent pending on it.
Now, JD, why would you do that? Why would you put patent pending on something?
The most important reason is not actually to impress customers, which does a little bit, but mostly to let the bad guys know or prove that you put them on notice. Okay.
And that gets at what, JD?
I look at this. Hey, sliding $1. That gets triple damages.
Treble damages. All right.
They say treble, but they really mean triple. It just means big trouble. And it's a huge major threat to the legal hammer. No one wants to go to litigation and face the triple trouble. We've got I love this. We got IP attorney, I think, or at least agent up there. I'm not sure, Philip. I see a wait time of 18 to 20 months before first action. So that's typical. Okay. And in Canada, you have to request examination. Yeah. Same here. Okay. All right. Let's go back to the trademark side. We'll kind of do this a couple more times, and then we'll go to our bold bites. Again, we see a couple of live folks out there. So if you have any questions, fire away. We'll take those as priority. I'll just keep going through our Reddit questions. So this one.
If you're going to do the Reddit stuff, then I think you have to include the username so that I can say username checks out, which is, someone has to say it every time in a Reddit thread.
Really? Well, I'm on a spreadsheet now. Is that going to bother you if I'm reading out of a spreadsheet?
No.
Okay.
Do it.
Got it. The title of this one is Just Making Sure I'm Not About to Waste a Trademark Application and Pay Fees for Nothing.
It's a real possibility, especially if you're filing by yourself.
All right, here we go. Hey, gents, how'd they know? I'm starting to sell whatever I happen to find in demand on Amazon. I want to trademark my products with Montana made. My name is Montana. I'm designing the goods. I would like a guy named Montana. Maybe he lives in Montana. I don't know.
Oh man,
I'd like the sounds with the alliteration of the double M.
Of course, yes.
Looked up the trademark database, and Montana made is trademarked twice in 2 companies using it for media, covering the businesses in the state of Montana. Can I use it? Because I'm not using it for entertainment, right? Different type of class, perhaps. What are your thoughts on that, Matt?
Well, I mean, first and foremost, that's a tricky one, right? Because it seems to me that that is fairly descriptive, right? It's
Right?
products or services made by Montana,
Right.
right?
JD made, right? Matt made.
Matt made. I mean,
Matt.
that's not really a trademark, right? That's descriptive of who's providing the services or the products.
Yeah.
Beyond that, right? I could see if this individual did not live in the state of Montana, I could see the USPTO coming back asking for more information, saying, is the service or the goods related to Montana at all, right? Asking for more information. And if he's not in Montana, right, you could presumably also get an office action for misdescriptive trademark, right? Because if the products don't come from Montana,
right,
and if they come from New Jersey, that's a misdescriptive, right? So
a double whammy.
Yeah, so I don't see. So yeah, stick that $250 back in your pocket, my friend.
Beautiful. And thank you for coming around. It started out with, hey, this is gonna be a tricky answer, but then you give a bulletproof solution right at the end.
Yeah. Sometimes I'm like, maybe depends, but like this one's like, nah, this is a terrible idea.
Okay.
So there's a better brand out there for him. That if he likes the M alliteration,
right,
there's something else out there better for him.
Gotcha. Here we go. Let's do invention idea taken. Dun dun dun.
Okay.
I may not have time for a bold bite again. I didn't actually prep one, so I like the questions. These are good. I know someone who has an invention idea that is very good, although I don't think he's patented it. Oh, the idea is very good. Not the person, and it is just sitting on it. I think he's drawn designs up and files on a USB stick, but heard it's not patented. I hate to see his great inventions sit and collect dust. And I know it's not the nicest thing to do, but
it is not the nicest thing to do. These guys are real.
I love that. I know it's not the nicest thing to do, but
work.
Would it be illegal through IP laws, copyright laws, to take the invention and bring it to life myself? Oh my gosh. The backstabber.
Yep, total backstabber.
Dude. Well, can you really call him a friend? I guess he didn't say friend, someone. Okay. So there's a fundamental issue here. You're not the inventor.
Ta-da!
Yeah, actually, turns out you have to be the inventor to not defraud the patent office when you're filing an invention. They do make you sign an oath saying you are the inventor. Therefore, it's unacceptable. And so you'd be defrauding. Either way, if you filed this and signed it as if you had invented it, shame on you. You're a fraud. Can't allow that. Don't do it. There's even a method for this individual, should they see it come to light, whether through a publication or eventually come to grant, through a new derivation proceeding. They could say, no, you derived it from me, and I elected not to get a patent on it for whatever reason, but I can prove that you got this from me, and it's mine now. Thank you for getting the patent. So don't do it for double reasons. It's a bad one. All right. Let's jump over to trademark side. No live questions as of yet. Okay, do you want to go with petition to cancel trademark?
Ooh, yeah. I love those.
Like that?
Those are great. That's my jam.
Or trademark lawyer says my application has a moderate to high risk of rejection.
Petition to cancel. Both real quick.
Okay, here we go. It's a long one. I'm going to use my radio voice for this. Oh, it's loading. Oh no. I applied to register my trademark in 2019 and it was approved in 2020. This month I received a correspondence from my attorney who's representing another business. His client had their trademark application denied based on my current trademark. They're asking for a consent to register agreement and are stating they will petition to cancel my mark if I refuse. I do not really have an opposition to doing a consent to register agreement. I don't really see how that will harm my business, and so on. You kind of get the gist of it?
Oh, yeah. All right. So this individual was probably the second to use a similar or likelihood of confusion-based trademark, right? So they have a confusingly similar trademark to a senior user who did not register, right?
Yes.
Now, senior users saying, okay, like, hey, we want to trademark, this name, but it's already been kind of registered by this third party. What should this individual do?
Yeah.
This is pretty common, right? And so if there really is no likelihood of confusion between the two parties, different customers, different brand, but the USPTO still finds something, I generally will encourage clients to consent to, the third party application to avoid my client being faced with a cancellation proceeding. This individual, his trademark registered in 2020, so he does not have what is called incontestability status yet. So after 5 years of registration, when it's time to renew the trademark between years 5 and 6 post-registration, he can file what's called a Section 15 incontestability claim, right? So basically, third parties cannot, go after his trademark for a variety of reasons, right?
You're exactly right. Yeah. So the senior user was claiming their wording back from 2014.
Yeah.
This user was from overseas, and they
didn't
land in the U.S. until 2016. My business was started February 2016, so pretty close timing.
Yeah.
Using my very similar exact wording, but unregistered trademark from the beginning.
Yeah. Right? So, I mean, typically in this situation, if a third party approaches myself or client, right, and they ask for a consent agreement, I want to see proof that they actually have better use than my client. Okay. Right. So I need to see the proof. Once I am satisfied that they have better use, then we'll discuss basically if we want to consent or not. Generally, the answer is yes, consent. We may not do a coexistence agreement, which is different.
Okay.
And then, finally, like if it's really adverse to my client, it's going to be expensive to my client. I might ask that third party to pay our attorney's fees for that consent agreement.
So walk me through. So I've got whatever JD's shoes. That's horrible. I've got both patents. And let's say there was actually a bold inventor law firm that had been around since 2005. Yep. I've registered. They're claiming an earlier use. Of course, I have this, like you said, special rule of being uncontestable. Yep. But I'm trying to come up with a little example. So they're coming in.
You cheaped out. You didn't file the Section 15. You didn't want to pay the $200 for it, right?
Okay. Yeah. There you go. Yeah. So I'm going to allow them to register?
Well, depends, right? I mean, how serious are they about filing a cancellation proceeding against you? How close are the clients to your clients, right? Uh-huh. Is there likelihood of confusion in the marketplace, actual confusion?
Yeah.
But you might elect not to.
Okay.
Or you might get that email from that third party's attorney that says we're going to cancel, and you might say, Matt, can we file that incontestability document still? That's always a kind of a concern too, is, how do you strategize around these things to not, tip people off to what you're doing?
It's super good. So I guess this is I've never actually touched on this. So this is great. So back to this person's question. So they're going to, you might recommend moving forward, having them pay your attorney's fees to do this.
I mean, I would recommend maybe having, asking them to pay attorney's fees so that, the job gets done correctly. Your interests are protected, right? You're not going to be limited going forward. And
obviously than a coexistence.
Yeah. I mean, and they're both kind of at fault. And so that might be the reason why they push back. I mean, this individual might be at fault because they didn't do a thorough search. They didn't see this third party before they filed, even though they were unregistered. And then, the other party's on the hook for this too, because they didn't do the right thing, which is to file the trademark early.
Yep.
Right. So it just gets more expensive for both parties at this point.
Awesome.
Yeah. Very, very good. Last thought too. I mentioned consent and coexistence agreements.
Yeah.
They're different. Consent agreement allows the trademark to register at the USPTO. It's a document that you hand the examining attorney at the USPTO.
Which would mean both marks could both be registered.
Correct. Simultaneously.
Yep. Without any agreement as to who has what, who controls what.
Yep. And that has to be approved by the USPTO. So the USPTO examining attorney still has to accept the consent agreement. The coexistence agreement is kind of the rules of the road outside of the USPTO. So I get east of the Mississippi, you get west of the Mississippi. Right. I will not use the word IP in my brand.
Contract law. Negotiating a contract between the two of you.
Yep. A private party contract.
Yeah. We did that with a firm.
Yep.
You remember that?
I do.
Yep. I don't know if that.
Colorado.
Am I free to share? I don't think it's confidential. But anyway, yeah, company called Bold, and yeah, so they're not allowed to use certain wording on their website, for example.
Sure. Yeah. You want to avoid those keywords.
Let's do one more question. I'm enjoying this kind of Q&A format. Again, if you have any live questions, we have a few more minutes, probably 5 minutes left, and we're going to cut. So if you have a burning question, something you're thinking about, fire away. On the patent side, I've got a couple left here. I'll take this one. Looks like an easy one. I was working at a big company as a design engineer. I came up with a design that helped cooling an electrical component by changing the way it sits in the airflow. The patent lawyer said, I'm guessing it's the company, the big company's patent lawyer, said it's not patentable.
Yeah,
I don't agree with that.
What does the patent attorney know, right?
Okay. All right. I'm going to come back to that. Is there anything that can be done to patent the idea? FYI, I don't work for the company anymore. Okay, we've got a couple issues here.
Yep.
So it's a patent lawyer. They have a 4-year scientific degree. They went to law school. They passed the state bar, and then they passed the patent bar. They're dedicated to knowing about patent law and technology. If they said that to you, you might want to go with them. I would even be more convinced if they had done an actual patent search, not just gone off the cuff. So, if they did a little research and took a look and see if your invention is novel and non-obvious, or if they were able to tell you based on an eligibility perspective that what you've developed is really more of a law of nature or a natural phenomena or abstract idea, then I would be, in agreement with the lawyer saying it's not patentable. This is looks like a design for a cooling electronic component. That sounds physical. Does not sound abstract to me. So that issue aside, usually, especially at a big company that can afford to hire lawyers, in your employment agreement, you will likely find an obligation to assign your inventions to your employer while you're working on the job. So assuming you're a design engineer and that your design for the cooling of an electronic component was somewhat related to what you were doing on the job, it's likely going to belong to the company, even if it were patentable. Even if
what if he did this on his free time at home at his mom's house? And then what also if he did it at his mom's house with his company laptop?
Oh, be careful. Whenever you use employees' equipment, whenever you're, on the clock, or if it's on the furtherance of a job, if one of your boss or superiors asked you to do something, then you're in trouble. That company could still own it, right? If you're on the company phone, company laptop, like you said, the best scenario would be to make sure that you might individually own it on your own time, on your own equipment, right? And not related to your job description. Then you have the best chance of owning it independently. But yeah, even though you don't work for the company anymore, it still was invented while you were on the job. So you likely are going to be out of luck there. So great question. Matt, thanks for the prodding there.
Yeah. So, basically it sounds like if you don't like the answer from one patent attorney, go to another one.
Yeah. That's right. Yeah. I have not interfaced with attorneys at, the sort of in-house attorneys. They're going to be biased toward the company. They may have their own agenda. What I mean by that is that in a big company like that, you can do interesting things. You have whole R&D departments that generate ideas, and they'll keep them in a little, trade secret incubator. And they'll say, well, hey, this isn't necessarily something to patent right now. Let's keep it cooking. Let's keep this in-house, confidential, under wraps, prove it out. And then we'll go dump 20, 30, 40, 50 grand acquiring a patent portfolio around it when the market's ready. So lots of different reasons to take different levels of risk with the bigger companies.
Well, that was great. I think we did a really good job. I'm going to go ahead and give us a A+.
Thank you, Pat. I'll go and take it. I think you did excellently. I was able to get around the horn myself. We covered some stuff. I'd never heard about the trademark side where you can kind of, you don't have to do a coexistence. You can actually let them register.
Yeah, I oftentimes, especially with clients who have something to lose, kind of like who are hoping to franchise, the franchisor clients, right? You do not want a coexistence agreement because then you have to disclose that to your franchisees and the franchise disclosure document, the FDD, and you don't want that, right? So a consent agreement is
cool.
Palatable.
Yeah, very clean too. On the up, it's all documented with the USPTO and everything. There's no really way to. It's almost federal, if you will. There's no contract negotiation.
Yeah.
Right on. Well, that's the end of our program today. We're skipping the Bold Bite. We're going to miss next week. I'm off going to Cabo, Mexico.
Sweet. You're going to Cabo. I'll be in the UK.
Yes, that's right. You're doing Scotland?
We're doing Ireland, Scotland, and England.
Ireland, Scotland. Oh, my gosh. So that's a dream. That's a dream vacation, man. Have you guys been before?
I've not been to Ireland or Scotland. I spent quite a bit of time in England, traveling and on business, but not Scotland or Ireland.
Very cool. Well, very good. Well, we'll be back on Wednesday. What's it going to be? The 29th. Yeah.
I may not be back by then, so you might be flying solo.
Okay. We'll fly solo. We'll be on next. So 2 weeks from today on the Bold and Better Show. For Matt, myself, and Bold Patents, wish you guys a wonderful couple weeks here. Happy Thanksgiving. Go big, go bold.